because it's not properly in front of him. So,
Well, all I can say is that, I mean, this is a very profile case. There's a lot of claims regarding the best interest of my kids. Like this is, it needs to be done at a very high level for the best interest of my kids and prepared carefully.
Right out of the gate, you can feel the tension. We've got a high conflict custody battle where Dad, Mr. Shepard, is already talking about false accusations and the best interest of his kids before the judge can even get into the substance. That usually tells you two things. One, the stakes are enormous, and two, both sides are gearing up for a long fight. On the other side, we'll soon hear from Mom's attorney, Miss Judd, who claims the children are scared, emotionally damaged, and even sleeping on a kitchen floor. And somewhere in the middle of all this, allegations about video games, threats against Mom's new partner, and questions about Dad's medical fitness to drive due to past seizures. As you're watching, ask yourself, is this about two parents fighting each other, or is this about three kids caught in the crossfire? Stay with this hearing until the end, because the judge is going to make a move that doesn't change custody today, but absolutely changes the pressure on Dad going forward.
And because of there's false accusations, there's concerns with
well, let me get you straight first. Let me get you straight first. Whose false accusations? Miss Shepard, Miss Judd, or your kids?
Miss Shepard.
Okay. All right. Okay. So
and there's a lot of again, this is a very complex matter, especially when it's pertaining to the custody of my kids. We can have a really detrimental mental health status with me potentially losing custody of my kids, and this needs to have proper legal counsel to not only gather the supporting evidence to counter her claims, which takes a little bit of time, but again to gather supporting evidence and to have again proper counsel and defending these accusations.
okay, thank you. All right, let's get to Miss Judd's motion, please. I read your motion, Miss Judd. Is there anything you would like to add? I do have a few questions for you after you've said what you're going to say.
Of course, I tried to be thorough in the motion itself. I guess I wanted to just address one comment that Mr. Shepard made. I do not believe he didn't get the email until the 27th. I sent it to him on Wednesday night after my client had secured the children. And I did that on Wednesday so that the children would be with her when Mr. Shepard received the email. I'm fairly confident that he had received the email by the following night, as he had then on Thursday taken it upon himself to have the children playing a first-person shooter game, having them pretend all the enemies were NP, my client's paramour. This has escalated to a really concerning level, and I'm really worried that somebody is going to get hurt here. So I'm trying to be thorough and forthright in my disclosures. This was originally accompanied by an ex parte request, which was denied with a suggestion that CPS be utilized. But my client has utilized CPS. They've been contacted 3 times now by the child's therapist, the eldest child's therapist, to no avail. I read that myself in the therapy notes. I did not disclose all of the therapy notes. I quoted some significant portions of them, but I'm trying to respect these children's privacy. And I suspect that CPS isn't stepping in because a majority of this is psychological, less the admitted slapping that was littered throughout the therapy notes. I've got a nearly 10-year-old girl now without a bedroom, reported to her therapist to be sleeping on a kitchen floor. So something needs to change here. My client does not want to cut Mr. Shepard out of these children's lives, but he's not participating at all in their therapy. I think this has become somewhat of a game, but these kids are suffering. These kids have now documented disorders. They are scared of him. They are being harmed in his house, and he's on some crusade here to ruin my client's life and her paramour's life at the expense of these three children who all they want to do is have a relationship with both the parents. The therapy notes were terribly sad. At such time as we have a hearing, I suspect all of this will come out. But these kids are terrified. They're terrified of the situation. They're terrified of retribution. They're being physically disciplined as a result of all these disclosures to their therapist and to my client. And Judge Gottlieb has already given Mr. Shepard a stern warning to move on. Let it go. The divorce has happened. My client has moved on. Everybody can move on and be happy. We just need Mr. Shepard to get on that train. And I'm not sure what the roadblock is here, but I think we need to look into the root of this concern, because his taking his anger out on these kids is really escalating to a concerning level. I think at a minimum, we need to implement a supervision requirement. Until we can get into this, I think it would be imperative for him to participate in their counseling for once, so he can hear firsthand what kind of psychological trauma this is causing to the kids. And I would also request verification from a medical provider of some kind that he's even cleared to drive, because we've got a history of intermittent seizures. I don't know if he's being cared for properly by a medical provider. I have no idea if he even is cleared to drive. I'm not sure if he's had subsequent seizures, but like I said, I'm really worried here that somebody's ultimately going to get hurt. I would prefer that not to happen. So my client has turned to this court for relief.
That was a lot. Let's unpack what Miss Judd just laid out. She says Dad put the kids in front of a first-person shooter game and had them pretend the enemies were Mom's new partner, Impy. That's not just petty. In a courtroom, that starts to look like weaponizing the children emotionally. She also claims CPS has already been contacted 3 times by the eldest child's therapist, but because much of the harm is psychological, there's been little concrete intervention. Add to that a nearly 10-year-old reportedly sleeping on a kitchen floor, an ongoing slapping mentioned in therapy notes, and the narrative shifts from messy divorce to potential ongoing harm. Her ask isn't to erase Dad from their lives. She stresses that, but to impose supervised parenting time and force Dad to engage in therapy and provide medical proof he's safe to drive, given his history of intermittent seizures. Question for you. If you were the judge listening to this, would you already be ready to limit his time, or do you think these claims still need serious testing at a full evidentiary hearing?
Thank you. The question I have is, and it's somewhat concerning, when I read your paragraph 53 in your motion, I became concerned, because what that tells me is that the only reason that your client agreed to a consent judgment of divorce was with that paragraph in there. And that seems to run afoul of when they raise their right hands and tell the referee or judge that this judgment is in the children's best interests. Paragraph 53 somewhat indicates that it's not, that it was only done out of convenience by your client to get this done, and I'm troubled by that.
Oh, I certainly didn't mean to suggest that, Your Honor. I was suggesting that it was important to Mr. Shepard to have the label of being a joint physical custodian. And despite the reality of the schedule operating in a manner that had rested physical custody with my client, at such time as mediation was happening, we all just agreed to have the label of joint physical custodians, with everyone being on the same page that we didn't have a joint physical custody arrangement. The parenting time schedule doesn't dictate a joint physical custody arrangement. And subsequently, because of her attending the medical appointments, her spearheading the therapy, her spearheading the school activities, she really is the primary custodian. I had referenced that merely to address the burden here moving forward. I certainly didn't mean to suggest that my client had created any kind of false impression to the court. The parties were getting along a little better at that time. And like I said, in the judgment, there was intention of expanding the schedule. So it was anticipated that perhaps the parties would be joint physical custodians if Mr. Shepherd did the things that he was supposed to do. But that didn't happen, and time had passed. So the circumstances have really created a primary physical custodial environment with my client. That's what I had intended to suggest.
Also, the last question I have, and then we'll hear from Mr. Shepherd. Why hasn't, maybe he has, I don't know. Why hasn't NP gotten a personal protection order?
I believe he's in the process of doing that, Your Honor.
Okay.
And frankly, the answer is everyone's been trying to keep the peace, but
Yeah, that would be because I don't know about your initial thoughts, but a PPO against is it a live together partner or not?
it is as of recently, and that's what has sparked the escalation and the comments to the children.
Because that could sure complicate things.
And that was, yes, and that was the other reason why there was hesitation, because I mean, my client, frankly, like I said, has been at war with herself as to how to handle this because she's trying to keep the peace. She genuinely wants to be able to get along for these children, but I'm not really sure what else she can do at this point.
No, I think if these are true, and I don't know if they are, I'm just going by what I'm hearing. And that's why I asked Mr. Shepherd, who's not being truthful, because obviously these threats are, at least alleged threats, are being made from the children. So I guess it would mean that the children are not being truthful, but we'll cross that bridge when we get to it. But I think NP, I don't represent him. You don't represent him. Nobody does. But if these are in fact true, then he should approach the personal protection order office. But Mr. Shepherd, your thoughts, please.
Yeah, there's a lot of points to go over there. So, yeah, excuse me if I jump around a little bit. I was actually on call last night,
Me
working
too.
in the morning on a mental health case. So, first thing is, there's a history here of parental alienation that I originally presented to the court, but evidence wasn't allowed. They did not want me to allow me to present that. First of all, our daughter, let me get my notes here. So first of all, our kids do have an adjustment disorder and do have anxiety, but there's a lot of factors that affect that with children. Our daughter has a very high genetic and environmental risk for anxiety. In fact, clinical literature shows that she has an 85 to 90, between 80 and 90% chance of predispositioned anxiety because of, first of all, Jenny and I both have a history of mental health disorders with anxiety. When you experience multiple residential moves, when your kids do have issues with learning, all of these things in conjunction, give you a high disposition of having anxiety. So there's a lot of other factors that affect, our children's mental health that are not being, discussed. And then you throw in, having, there's basically research showing that introducing a step parent as a parental father figure to your children early on before the age of 6 can have a mental health effect for your children. There's been 2 instances where my Jenny has, tried, done emotional damage to my kids by like for instance, like bringing him to games and having him take my kids to like their events, which should be done by the primary, like the both primary parents. Um, you know, having the boyfriend take father-like pictures and then exposing them to me, and my kids. Just when you bring in a secondary father figure early on in a children, that can cause, um, again, that can be a factor when you're, looking at, the effect of the mental health of a child.
I
Um,
understand that.
the
Let
other
me
thing,
ask you this. Well, let me ask you a couple of questions and see if we can't,
can I say one more thing really quick before you comment?
if you need to.
Yeah, so the next thing too is there's been a lot of gaslighting that has caused anxiety and fear in my children. So for instance, in the letter from the behaviorist, first of all, there's misinformation in there. My Jenny, I don't have epilepsy. I did have a seizure in November of 2022, which was documented. My doctors have made a clinical decision that that was a drug-induced seizure. Prior to that, I did not, and I've been medically cleared. We fixed the problem. I haven't had a seizure since. I didn't have a seizure in December of 2024. I don't know where she makes claims on that. I did pass out, and I was on a diet in December where I was fasting, and we believe from what a family member at my house thought that I passed out, and it could be related to my diet. He did not say I had a seizure. Jenny just assumed I did. And prior to that, I didn't have any seizures for the last like 3+ years. But Jenny wants to portray that I did and gaslight my children in being fearful that I'm not healthy, that I have seizures, and are scaring them where I don't have the ability to drive with them. And when I've been clearly cleared by my doctors, and I've shared that with Jenny, that I've been cleared, I have been seeing a doctor. There's no medical reason why that could cause a fear here. But she keeps gaslighting my children as part of her alienation tactics to, again, put her in a better position than me and try to, again, reduce my fathering. I mean, there was in the past, she has stated that she was going to ruin my life. When I said I eventually wanted to get full 50% custody of my children once we made some changes in my household regarding the bedroom status, she said, no way, like that's not going to happen. The kids need her mother.
Okay. I've let you go for quite a while now. When you said there's one more thing, and then you proceed to talk for 15 minutes.
Sorry.
So let me ask you this. You can understand, can you not, that the fact that you had 2 episodes while you were driving, and whatever you want to attribute those to.
I never had one driving.
See, that's what you can't do, Mr. Shepard. When I give you the floor, I give you the floor, but you can't interrupt me. Okay, that would be a nightmare today.
Sorry.
So, but having these types of seizures anyway, whether they're a seizure, whether they're an event, and I really don't care what caused it, because the paramedics won't ask what caused it when they're digging you out of a car if that happens again. So I think, first of all, and you can put this in the order, Ms. Judd, I want a recent medical clearance that you are able to drive without restrictions. That's number one.
Perfect.
The second thing is, I want, certainly, in my view of reading all of this, um, all I need to do today, and there's been a lot of psychological terms bantered around today without, quite frankly, any supporting proof of that. Gaslighting, parental alienation, those things are becoming mental health issues now. And I wouldn't know that. But the motion asks for a change. And in order to do that, I need to assure myself that there's been proper cause or change of circumstances pursuant to the case of Bodvarka versus Grassmeyer, 259 Michigan Appeal 499, a 2004 case. And they can't just be any proper cause or change of circumstance. They must be things of significant magnitude um, uh, that could have a significant effect on a child's life or well-being. The matters listed in the motion include the fact that one, you no longer participate in therapy with the children. Two, the inappropriate behavior in front of the children starting in 2023. Threatening plaintiff's partner NP in front of the children, that's the allegation. Four is the children's fear of the defendant. I don't know what that's all about. And the whole concept of driving with the children, it could cause an issue. I don't know if any of those are true to the certainty that's required to change custody, but that's not my job today. My job is only to find whether there's been proper cause or change of circumstance to at least stick my nose back in it. And as Ms. Judd knows, I don't like to do that at all. But in this case, the relevant best interest factors are found at MCL 722.23, and they center around factor B, the capacity and disposition of the parties to give the children love, affection, and guidance. That's particularly the mental and physical health of the parties involved. And this whole concept of they've really expanded the definition of domestic violence. I'm not so sure that if these allegations are true, that threatening these types of behaviors against NP would not amount, in this case, to the expanded definition of domestic violence. So, but I don't know that, and we're going to get to the bottom of all that. So I am going to grant.
Here the judge finally shows his hand, and it's more technical than dramatic, at least on the surface. He's not deciding who's right about every accusation today. Instead, he's asking, is there enough here, proper cause or a change of circumstances, to reopen this custody situation at all? That's where the case Barca versus Grassmer and Michigan's best interest factors under MCL 722.23 come in. The law doesn't let a judge change custody just because things are unpleasant. The change must be serious enough to potentially impact the children's well-being. So the judge lists the allegations. Dad no longer in therapy with the kids. Inappropriate behavior in front of them. Threats toward NP in their presence. The children's reported fear and the driving/seizure concerns. He makes it clear he doesn't yet know what's true to the certainty required to actually switch custody, but he does find enough to investigate further. That's why he grants the motion in part. He's opening the door to a deeper probe, not slamming down a final verdict on custody. Would you be relieved by this cautious approach? Or do you think the judge should have gone further and immediately restricted Dad's time?
The plaintiff's motion in part, I am going to first require that Mr. Shepherd provide Ms. Judd with a copy of a very recent doctor's note that
Perfect.
at least claims that, or at least states that you are free to drive without any type of restrictions. And it might be a good idea to have that physician or whoever acknowledge that you've had these issues in the past and that they've been rectified. I'm also going to order that the friend of the court conduct an investigation and evaluation into the concept of custody. The fee for that will be divided between the parties, $150 apiece. I am going to take under advisement the other relief requested, to and including eliminating overnights. If things continue, you can bring that back to me again, and I'll present an interim order, Ms. Judd. But that's what I want to have, at least initially. And we'll see where we go from here. And you'll have plenty of time, Mr. Shepherd, to contact legal counsel of your choice. And I don't think we've done anything that would implicate the custodial environment at this point. So I think you're okay from that standpoint. Is there any questions, Ms. Judd, on what I need the order to say?
I just have a question, Your Honor, just because I've had this happen a couple of times now. I'd prefer the order reflect that my client pay the full fee and Mr. Shepherd reimburse her his half, if that would be acceptable, just to prevent any administrative dismissal in the event of not paid.
That's fine.
Okay, that's the only question I have.
I'll do that. And then you can just pay, send a check to Ms. Judd's office, Mr. Shepherd, for the $150. And Ms. Shepherd can pay the fees. And we'll see if we can't get to the bottom of all of this. And I take it if, some of these things are very disturbing, and I hope that I hope that if they are occurring, they stop, because the last thing in the world you're going to want to do, Mr. Shepherd, is have a three-front war between you and your children. That would be very detrimental. So I will do that order of reference, Ms. Judd, today. And is there anything further from your end?
I have obviously some comments to what Mr. Shepherd had alluded to with his seizure, but we've taken up plenty of time. We can address that all in the future.
Thank you. Mr. Shepherd, anything else I can do for you?
So where did this hearing actually land? Despite the explosive allegations, video game target practice on INPE, therapy notes about fear and discipline, concerns over seizures and driving, the judge did not change custody today. Mr. Shepherd keeps his existing weekly parenting time, but beneath that apparent win is a serious warning. He's now on what the judge calls a short leash. Practically, that means three big things. First, he must provide up-to-date medical clearance, proving he can safely drive the children and that any prior episodes have been resolved. Second, the friend of the court will conduct a formal custody investigation, interviewing the parents, reviewing records, and weighing best interest factors in detail. Third, the court has left the door open to future restrictions, including cutting overnights, if the troubling behavior continues or is confirmed. The broader takeaway? Family courts move carefully, but when kids show fear, when therapy records hint at psychological or physical harm, and when domestic violence concerns touch new partners, the system will eventually dig in. This isn't over. It's the beginning of a deeper review of dad's conduct and the children's safety. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
So is there a change of custody then?
No.
So I keep my children during my weekly time?
Yeah.
Thank you.
But you're on a short leash because you got the eyes of the court on this now.